And I'd like to call today's hearings with an S to order. And the first case we'll hear will be Cal Portland Company, case number 3221-23. We do have a host of exhibits.
Mr. Chair, if I could ask, the district would request to take the other matter first, just because I have witnesses with a little bit of a time.
Sure, no
crunch.
problem, no problem at all. Okay.
Thank you, Mr. Chair.
No problem. We'll take Amazon.com Services LLC, case number 6267-1. And so we have a multiple exhibits. Would you like to call them out? So the document before us is the interim variance conditions. Okay, these are A. Exhibit A. And then okay, so hold on. All of these are you stating that the interim variance conditions would be a part of Exhibit A, which is the timeline of events? Because there's 3 of them. There's 3 of them together. Right, so the
petitioner labeled their exhibits with letters, which are traditionally for the respondent, but
right.
I think we can reverse that for ease if that's.
No problem at all. So we'll go, on the variance conditions, the district, this is A. No, we'll go A.
A?
We'll go A.
Okay.
Then Exhibit A on the petitioner side will be 1. Exhibit B will be 2. Exhibit C would be 3. Exhibit D would be 4. Exhibit E would be 5, which is the maintenance schedule. Exhibit F will be 6. Yes, the district has an interim variance condition, which would be Exhibit A, and then there's another document, which is the equipment description, which is B, and then the notice of violation, which would be C. Is that all? Is that correct? Okay. Who do we have representing the petitioner?
Good morning. My name is Ryan Schaefer, RyanSchaefer. I'm a regional environmental manager for Amazon here in California.
All right, representing the district.
Good morning, Mr. Chair. Catherine Roberts on behalf of the executive officer.
All right, do we have witnesses? Do we have any witnesses on either side? Okay. And so why don't we have all of the witnesses to stand?
Yes.
And the witness from the next area as well.
Yes, absolutely. We'll take the oath for everybody. All right. Please raise your right hand. Do you solemnly state under the penalty of perjury that the evidence that you shall give in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
Let the record reflect that all have agreed in the affirmative and have accepted and been sworn in accordingly.
Yes, consent.
And affirmed either way. All right. Opening statements. Mr. Schaefer.
Thank you. This will be brief. As a result of the Santa Ana wind events that we all experienced in January, Southern California Edison performed several public safety power shutoffs, which I will refer to just as shutoffs for the remainder of this hearing, across their grid to mitigate additional wildfire risk and public safety. These shutoffs impacted our building throughout the month of January, which resulted in excess or above normal engine runtime hours from our emergency generators. Our building was tracking this, and when it became apparent the risk of exceeding these permitted hours, the general manager of the building notified me, and then we filed for an emergency variance immediately. As of today, though, we have not yet exceeded these maximum runtime hours. The maximum limit is 200, but we are very close. As of February 12th, our 3 permitted engines are at 182, 185, and 72 hours of operation for the year. As we see in Exhibit A, we proposed variance conditions include limiting future maintenance and testing to 1 hour per month and up to 4 hours 2 times per year for the annual and semi-annual load bank testing. And then engines are only going to be operating for emergency situations only. That's all I have.
Thank you, Ms. Roberts.
Thank you. Good morning, Mr. Chair and members of the board. The district is unopposed to the finding of good cause to proceed in the absence of notice in this matter. And the district is further unopposed on the merits of granting a variance as to 2 of the engines listed in the petition. As to the 3rd and 4th engines, these are permit numbers G73659 and G62949. The district believes that the evidence will show that these engines have expended less than half of the maximum permitted, which, as Mr. Schaefer noted, is 200 hours per year. We believe as to those 2 engines, they cannot currently meet variance finding number 1, that they are or imminently will be in violation of this permit condition. On discussion with the facility's representative, the district understands that the facility may be willing to withdraw the petition for the interim as to those 2 engines, and only seek variance relief for the other remaining engines that are much, much closer to the 200 permitted hours, with an option to revisit additional coverage at the regular variance hearing should it be warranted. The district will note that there is a minor technical correction that we are requesting to Exhibit A, which is the proposed interim variance conditions, to remove reference to one of the permit numbers, G73659, from conditions 1 and 6. So there should only be 2 referenced permit numbers in those. The district does wish to further note that should the board find good cause to proceed in the absence of notice and proceed to the merits, the district will have a witness, our air quality inspector, Daniel Calderon, who will testify to his observations that occurred during an inspection of this facility last week. In his testimony, he will discuss how he discovered multiple additional internal combustion engines that are not permitted and which were not disclosed as part of this petition. The district, on the basis of this new information, has amended and submitted revised conditions from what was seen in the emergency variance for this matter, on the basis of this new information, to ensure that this unpermitted equipment does not operate along with the engines that are being considered for a variance. As the board is aware, the Health and Safety Code Section 42350 prohibits granting a variance from the type of violation of getting a permit itself. So the district's proposed conditions are aimed to align with that legal requirement and would remove those engines from operation, so the board can consider granting a variance as to only the permitted engines here. And subject to the inclusion of those conditions, the district will be unopposed to the variance for those 2 engines. Thank you.
Thank you, and I assume that you're not calling any witnesses on either side? Okay.
The district will have it if the board proceeds to the
Right,
merits, yes.
absolutely. All right, good deal. Are any questions?
Can I make a point of discussion? This is an interim variance, so we have to bifurcate the hearing. They have to do the good cause first, and then I don't know if the gentleman Mr. Schaefer knows about the procedure,
No, I believe he knows about the procedure.
so that we have to go through the good cause finding first,
Yes.
and then proceed to the next phase.
As in good cause, you're referencing why we were not doing a public notification, and this is the interim variance?
Address that, or
Absolutely.
and there are 4 findings you have to make for good cause. You might have are you familiar with those?
Yes, I believe I have 6 to discuss. Okay.
The 6th finding is the second phase. The first phase, we have to do 4 findings, which is 1, whether you're in violation, and then in violation. 2, it was beyond your reasonable control. The 3rd was you were diligent filing, and the 4th one, what impact, what the denial of the variance will result in. So those are the initial, 4 findings that you see there that you have to make initially. Address that for the board, and we can have a discussion on that and then vote on that. And then we will move to the next phase, which is the 6 findings that you alluded to.
Okay. Yes, the rule that we are in potential of breaking, I believe, is South Coast AQMD Rule 203 Part B, which states the equipment or agricultural permit unit shall not be operated contrary to the conditions specified in the permit to operate. We are at risk of violating our three permits, G73658, G73659, and G73660. Specifically, the permit conditions are the engine shall not be operated more than 200 hours in any 1 year, which includes no more than 50 hours in any 1 year and no more than 4.2 hours in any 1 month for maintenance and testing purposes. Due to the conditions beyond our reasonable control, requiring compliance with the permits as they stand would result in the practical closing and periodic elimination of a lawful business. As we talked about earlier, our engines were running as a result of the shutoffs controlled by Southern California Edison in response to the January Santa Ana wind event as a measure to protect public safety. We have no control over these shutoffs, and our engines respond when the utility is cut off from the facility. Our engines have been properly maintained since installation by following manufacturer's recommended maintenance schedule. We run weekly, monthly, semi-annual, and annual maintenance and testing to ensure minimal emissions. Sorry, I'm looking for the third one here. When discussing business revenue impacts as the shutdown of these buildings for this type of facility, it's almost unmeasurable, and I can explain this a little bit. This facility, which we refer to as site code SBD1, it's one of 26 core inbound cross-dock sites in North America that make up our network. Our main goal for the building is to take inventory from sellers and spread it across the network over 150 downstream fulfillment centers. As a result, this building really is purely set up as a cost center from an Amazon standpoint. In other words, we're unable to easily attribute revenue to the site as it's just pass through of inventory. We don't store or fulfill orders at this building. On average, this facility moves anywhere from 1.5 to 2 million units through the building per day. And this is during non-peak times. When I refer to peak, I mean towards the end of the year during Christmas time. That numbers increase during those times. The impact of shutting down an inbound cross-dock building for an extended time is immeasurable to a certain extent in revenue, but would be immense as like our downstream customer orders cannot be fulfilled if this capacity would cease to exist. We would lose revenue from sales on Amazon.com doing long lead times, sellers fees in which we charge sellers to move inventory swiftly through our networks, as well as increased transportation costs as we'd have to route the volume elsewhere. What I consider a greater impact to the business is not necessarily on Amazon. It's really the 1,251 Amazon associates who work in this building. Those folks, if we had no power to the building, would be sent home at the second we had these shutoffs. On average, this facility, I want to say the 2024 data, we lost 108.7 hours due to power shutoffs. If you multiply that by the average salary of associates, average number of associates during a shift, which comes out to 563 over 4 shifts through the week, those associates, they lose an aggregate $1.3 million in salary just from the 108 hours of shut off. So to me, that's a greater impact than any business risk we have.
Yeah, it started in.
Did I skip a step?
I think you went 4, but you didn't see 3. Scroll down.
Oh, where's your next building?
Oh, I guess. On the other side.
Yes, yes. As soon as the risk of exceeding our permit hours was evident, in January when we filed for this variance, which was about two days after we learned of our excessive runtime hours, we were projecting an exceedance of the permitted hours of 200 within days. As we have talked about earlier, that's not the case. These power shutoffs actually stopped right around the time when we filed for this variance. But at the time when we filed for the interim variance, we were on a trajectory to exceed these hours within the week. So we filed the variance immediately once upon learning this.
All right, members of the board, Ms. Fiduco Peralta?
Thank you, Mr. Chair. Don't we have to have?
Sorry, the procedure was we had to have the district
Correct.
ask the question.
Right, but you wanted personal privilege, and so I was going to grant her the same. Is that okay?
Yeah.
Thank you, ma'am, go right
I
ahead.
can wait until
All right.
after
No
Catherine.
problem, Ms. Roberts.
Thank you. I have a couple of questions for you, Mr. Schaefer. So at the good cause portion, we're really looking particularly at the timing of filing. So I wanted to point to you presented what is now Exhibit 1, a timeline of events. So I note essentially the first public safety power shutoff began on January 7th. Is that right?
That is correct.
Okay, and then a couple of lines down on January 15th, you said you emailed an emergency relief email to the AQMD and also discussed this with one of our the executives from our compliance officer, Mr. Terrence Mann. Can you elaborate a little bit on what you were talking about on those communications?
Yes, so at first, it was to discuss the applicability of Executive Order EO-01. From when I read it, it was not completely clear that it did not apply outside of Los Angeles County. This facility is located in San Bernardino County. So when I first emailed the emergency relief at aqmd.com and Mr. Terrence Mann, it was to see if this executive order would apply to our building. He confirmed on the 16th, I believe. Yes, he confirmed on the 16th that that executive order did not apply to our building because it lied outside of the county. But he then provided guidance on what we should do to remain in compliance, and that was by filing a petition for a variance. So that was when we took the next step and actually submitted the variance.
Okay, thank you. Those are all my questions.
Thank you. Members of the board, Ms. Verdugo Peralta.
Okay, were you aware of all of the engines that were not permitted?
We were not aware. I learned of this as of last Friday during the on-site inspection.
Okay, so I have no problem with the justification for the two engines that, and it appears those are the only ones that we can address based on the fact that, number one, the other ones are not even close to half, and then the other ones are not permitted at all. So you're going to be, how many engines were there that were not permitted?
So if we proceed to the merits, our air quality inspector will go over that, but that is referenced in what is now Exhibit B in the chart is the easiest way to see that. There are 3 non-permitted engines.
Okay. All right, so those are the ones that we can't even consider. So you're going, and I don't know what the hours are on those. Do you know what the hours are?
Yes, it is an Exhibit B. I believe the engines, the unpermitted engines are 1B, 2B, and 3A. Those hours for the year are 184, 192, and 178.
Okay, so those are the ones that we can't even consider.
That is
So I
correct.
just wanted you to make sure you knew that.
Yes.
Okay, that's all I had.
Any additional questions? Mr.
Yes.
Balakapalan.
So you heard Ms. Roberts saying at this time only granting 2 of the 3, right? Because which is so it's looking at the table, Exhibit B, you have G660 at 285 hours, correct?
Cumulative, yes, 182 for the year. Yeah.
And then you have G73658 at 297, correct?
Correct.
And then you have, what's the other one? The other one, I'm looking just at the permitted one. The third permitted one is G62949, correct? That is at 248.9. Correct?
I think G73659 is the third engine that I believe we're going to remove from this variance, as it's at 72 hours for the year.
Okay, so 72, okay. So we only do 660 and 658.
Yes.
Correct.
And that was stated by Ms. Roberts earlier, just for the record. Ms. Roberts had
Yes,
already stated
if we get to
that.
the merits, we will have a witness that will walk through all of this. Yes.
Very well. All right, any further questions, members of the board? All right, to closing statements, closing arguments.
Yeah, this is going to sound like I'm repeating myself here, but really, due to circumstances that was beyond our control, these Santa Ana wind events, SCE did what it needed to do to protect human life and property by issuing these shutoffs across their grid. These shutoffs had a massive impact to SBD1 to the point where we were in January projecting our emergency hour runtime hours exceeding the permitted limit of 200. In order to really remain compliant with AQMD, we filed for emergency variance requests with the board as a result. We did this. Our number one priority is really remaining in compliance with all rules and regulations. It's our main concern. It's why we're here today. My concern is of the 2,251 Amazon associates who, if this variance is not granted, could potentially lose up to 100 or more hours this year of work. And the impact on their household incomes and their surrounding communities would far exceed any negative impacts of any excess emissions from these engines during the remainder of the year. That is all I really have.
Ms. Roberts?
Thank you. With respect to good cause findings, the district does not oppose the findings. Specifically, finding number 1 with respect to engines 66 ending in permit 660 and 658. We do think that the petitioner has shown that they will be in imminent violation because of how close they are to their maximum permitted of 200 hours. We do think that they have met the findings for finding number 2, that the circumstances couldn't reasonably have been avoided. This was a public safety power shutoff called by SCE for public safety purposes. We do think they've met finding for 3. Specifically in their Exhibit 1, they walk through the timeline of when they have filed, and we do believe that meets the criteria for diligence. And we don't dispute Amazon's statements as to there would be adverse impacts in the absence of a variance. So we do believe the findings could be made here.
Members of the board on deliberation.
I'll go. I do agree. I can make this, the findings, this is the 4 findings that in violation. The reason I asked for the hours is because in your petition, you had different numbers stated. I'm assuming Exhibit B is the true one because you had stated 171 hours there in for 659. But just going by 660 and 658, those 2 are clearly imminently could be in violation. So you meet the one that and I think it was beyond your reasonable control, the shutdown. And then that and I agree that based on your timeline that you provided, you were diligent in filing. And then I think you mentioned the impact that the denial of the variance will have. So I'm satisfied that I can, move forward on the good cause portion of it.
Any other comments from members of the board? In the absence of none, I move in the matter of Amazon.com Services LLC, case number 6267-1, facility ID number 1929999. We find good cause to proceed to a hearing for an interim in absence of notice to the public based on our discussion and ability to make the findings for good cause. Is there a second?
Second.
Second by Ms. Verdugo-Peralta. Any further question or discussion? Hearing none. Dr. Abraham.
Aye.
Verdugo-Peralta.
Aye.
Balaka-Palan.
Aye.
Conacher-Macklin.
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. And we're now to the second phase of this process. We will incorporate all previous comments and or exhibits into the next phase, which is to approve an interim. So we'll move very quickly to opening comments from our very good friend, Mr. Schaefer.
Thank you again. I reviewed the interim variance conditions. We are in agreement of all conditions on there. I can confirm in Exhibit A, item number 2, about disconnecting and rendering the unpermitted engines inoperative. We have already taken this step. We have disconnected that unit from the others and actually physically lock out, tag out those units so they cannot run until we get them permitted. Regarding Exhibit A, item number 3, as of yesterday, we have the item number 3 states that we shall no later than February 28th submit permit applications for the unpermitted engines. Yesterday, we retained the services of our third-party consultant, ERM, to perform this for us, and we will absolutely have this submitted prior to February 28th.
Thank you very kindly. Ms. Roberts.
Thank you, Mr. Chair. Subject to the inclusion of those conditions, and with the exception of limiting it to only the 2 engines that are above 150 hours, the district is unopposed to the granting of an interim variance.
Thank you very kindly. Will we be calling witnesses if needed?
We will call our air quality inspector, Mr. Calderon.
Okay. Do you have any witnesses, Mr. Schaefer?
I do not.
Thank you very kindly, Ms. Roberts.
Can I have a question for
Go right ahead, Mr. Balaka-Palan. The floor is yours.
Mr. Schaefer? Looking at condition number 2, Exhibit A, would you understand by that? Because I'm getting a little confused with the language here. Shall disconnect, rent inoperative including disconnecting from the engine's reference in condition number 1 above any on-site generator. And then, basically associated with those unpermitted engines. So what, I'm a little confused with the language. What do you take from that?
Yeah, I'll admit I am not a mechanical guru, so these engines to me I don't know them perfectly, but I do know that our mechanical teams on site have essentially shut down those engines and locked the entrance to any sort of override system there. So these engines no longer are connected to the permitted engines. They are permanently shut down until we have permits in hand.
How can the engines be connected to the permitted engines? You're talking about the generator or because the engines, so can you
Mr.
clarify that?
Pallon, if I can, this is the district's exhibit and our conditions, and we would be happy to discuss that with our
Okay, I just
air
wanted to see
quality
if he
inspector.
understood what he's agreeing to,
Sure.
condition number 2. So, it looks like there's some, do you completely understand condition number 2, or you think some clarification will help?
I mean, clarification can always help, but I do understand condition number 2. We in no way are going to operate those unpermitted engines at all. And if for some reason these units are inoperable as a whole, if it's 2 engines supporting 1 generator, then we won't run either engine if that's the case.
Now, condition number 2 also says you cannot operate this engine until a permit to operate is issued by the South Coast.
Correct.
Right. Now, you mentioned you hired a consultant to submit the application. Are you aware once the consultant submit the application by the due date of February 28, you have a temporary permit to operate? And you can actually, once, that under the Rule 203C, you can actually operate those engines?
I actually was not aware of that, but thank you for bringing that to our attention.
Okay, so that's why I'm concerned about condition number 2, and I'll let, we'll address that later in the district witness.
Okay, Mr. Schaefer, Mr. Balakapana, can we move on?
Yes, I'm done. Thank you.
Very well. Ms. Roberts?
Thank you.
Your witness?
Thank you. So Mr. Shaver, I just have a clarifying question. Do you agree with the district's statement today that we are limiting for the interim? And this would be a change to conditions number 1 and 6, that we are limiting the variance being requested for the interim to just permit numbers G73658 and G73660?
Yes.
Thank you. Those are all of my questions.
Okay, so Mr. Schaefer has no witness. We're over to the district and the district's witness.
Oh, I'm sorry. There's one question for Mr. Schaefer. I did see in the petition, do you know who did the emission calculation for the excess emission in your petition?
That would have been me.
That would be you?
Yes.
Okay. And I noticed you used 499 hours to calculate, and are you aware of the proper procedure for calculating daily excess emission?
Yeah, the calculations I made in that application are incorrect, because at the time I was not aware of these extra engines that were on site. I was actually reporting engine runtime hours for an engine that we didn't have permitted. I was not aware. I just took the maximum number of that engine. They had it listed out as like 3A, 3B. I think it's 3A, 3B, and so the numbers are inaccurate in there. I can revise if necessary.
And not only the numbers are incorrect, but I think are you aware that the methodology used may be also something you may want to discuss with the agency to see how you should be calculating the excess emission, daily excess emission?
I will do. Thank you.
Okay.
Ms. Roberts, your witness?
Thank you. The district will call Daniel Calderon. Good morning, Mr. Calderon. Can I have you state and spell your name for the record, please?
Daniel, Daniel, Calderon, Calderon.
Thank you. And did you take the oath this morning?
Yes, I did.
Can you remind us what is your position with the South Coast AQMD?
I am an air quality inspector.
How long have you been with the South Coast AQMD?
I'm a 1.
Sorry. How long have you been with the South Coast AQMD?
Roughly 6 months.
Great. And in your position with the South Coast AQMD, are you familiar with the petitioner's facility?
Yes.
You familiar with the variance petition in this matter?
Yes.
Have you ever conducted a compliance inspection of this facility?
Correct.
What was the date of the most recent inspection?
February 14th. 2025.
So on February 14th, did you actually get to observe the engines that are the subject of this variance petition?
Yes.
Did you observe any other equipment?
Yes.
So I'm going to pull up, and I think we've already referred to this a bit before, but I'm going to pull up on the screen exhibit, what has been marked as Exhibit B, which is a chart. I'm sorry. Can you tell me, did you prepare this chart based on your observations of the facility?
Correct.
So I think we've already had a little bit of a question talking about the variance conditions. Can you explain to us how these there seems to be two different engines referring to each generator, such that there's, 3 generators but 6 different engines?
Yes. So each pair of engines are sitting on a trailer with one generator, both powering that generator.
So the engines, both a permitted engine and a non-permitted engine, are connected to the same generator. Is that correct? So in referring to condition 2, when we say we want certain engines disconnected from the engines that might be permitted to operate under this variance, is the intent to remove them from attaching to the generators that are being powered by the permitted engines?
Correct.
Okay. So looking at this chart, I want to call your attention to the second to the right column, from the second column from the right, where it says total 2025 usage hours. Did you confirm these numbers during your on-site inspection for each of the engines listed?
Correct.
And so I want to compare that to the column just to the left of that, where it says meter reading in hours. Could you explain to us what's the difference between those two columns?
Meter reading is total hours of that the engine has ever ran, not just 2025, and then 2025 is only that year's ran time.
Okay. And to your knowledge, the permit condition that's at issue in this variance petition is looking about cumulative hours per calendar year. Is that correct?
Correct.
So we are looking at that second from the right column of total 2025 hour usage. Is that right?
Correct.
Okay. So the permitted engines that start with the letter G on this chart, are those the same engines that are referenced in the variance petition?
Correct, except for one.
Which one?
Oh, actually, no, correct.
Okay. And so the units that are 1A and 2A, that's permits G73660 and G73658, the first two of the permit numbers. How many hours do each of those engines have respectively?
Can you repeat that again?
So let's start with the first engine. That's unit number 1A, 73660. How many 2025 hours does that engine have?
182.
And is that as of last Friday?
Correct.
So that hourly number might have actually changed since they filed the petition. Is that correct?
Correct.
Okay. And so the third column, or the third row down, 73658, how many 2025 hours does that have?
185.
Okay. So those are relatively close to their permitted maximum for the calendar year of 2025. Is that correct?
Correct.
And the other two permitted engines, those are unit number 3B and 4A. Those are less close. Is that fair?
Correct.
In fact, both of them are at less than half of their permitted usage. Is that correct?
Correct.
Okay. So I'm gonna stop sharing that. And if I can call your attention to the variance conditions that we've talked about a little bit, those are Exhibit A as introduced. So I want to talk a little bit about condition number 2, to disconnect and render inoperative, including disconnected from either of the engines. Is it your understanding that the purpose of this condition is to essentially take out the possibility of unpermitted engines operating even if this variant is granted?
Correct.
Okay. So condition number 2 also says they shall not operate these engines until issued a permit. Is that correct?
Yes,
And for the unpermitted engines, at the conclusion of your investigation last Friday, did you issue any enforcement action against this facility?
correct. A notice of violation.
And is that the same notice of violation that's in Exhibit C?
Correct.
And so that violation includes violations not only of District Rule 203, but also District Rule 201. Is that correct?
Yes,
Thank you. So, and condition number 3, we've already talked about, would require them to submit permit applications for those 3 unpermitted engines. Is that correct?
yes,
And so if they comply with conditions 2 and 3, would that essentially address the violations that you cited in exhibit number C?
correct.
Okay, thank you. Those are all of my questions for you.
Thank you, Mr. Schaefer. You have any questions of the witness?
Actually, I have no questions. Thank you for your time.
Thank you very kindly, members of the board. Go right ahead, Ms. Verdugo Prata, no problem.
Mr. Schaefer, on exhibit, this would be your exhibit F, that we changed to 6. On page 2, all of these events that I'm looking at are all dated in 2024. What was the purpose of you giving us this chart?
Yeah, the intention or the purpose of providing 2024 data was to give a more realistic of what an actual year looks like at this facility for power shutdowns. As you can see, in 2024, we had 11 events of utility shutoffs, totaling 108.7 hours of total building shutdown. I just brought that data in to really present it as what a normal year would look like out there. This area, for some reason, is really prone to utility shutoffs. The data from 2025 is kind of an anomaly. We all know what went down in January of this year, where we had over 170 hours of runtime on this 1 or 2 engines. If I was going to be asked to provide any sort of estimated loss in salary of associates by not working, I was going to use the 108.7 hours as a more representative number to calculate.
Well, on the chart, there's only 2 dates really that are attributed to PSPS events.
Correct. The utility took other measures regarding, looks like repair and maintenance, and even looks like overhead equipment components, which had melted apparently.
Okay, so your intention here was just to show what an average event could be, that you're saying you're prone to being turned off more often than normal?
Correct.
businesses?
And I didn't want to give the impression that I was calculating anything based off what happened at this year's event in January. I don't expect that. I prayed that we don't expect to see that again.
That's very true. Okay, I just wanted to know why we had that chart up here, because to me, it's still kind of irrelevant because we all know what occurred, and that you were not at fault. We're all aware of that in regards to those engines that were discussed and the ones that are permitted. So I just wanted clarification on that. Thank you.
Thank you.
Mr. Balakapalan.
Mr. Calderon, I got a question. Just to clarify, I think Mr. Schaefer did indicate he talked to Mr. Mann, and the emergency declaration that was issued by the EO was only for LA County and not for any other county, correct? And also your understanding that the PSPS Rule 118.1 doesn't apply to this facility because they're not a critical service facility?
Correct.
So they cannot, okay. So because I see that in the ex parte, there was a condition regarding PS.
Yes, that was included. Rule 118.1 was initially included by inadvertence.
Okay, all right. So it doesn't apply at all.
The district agrees it does not
Okay,
apply.
all right. So let's move on to condition number 2 then. Ms. Roberts, is there any chance you can bring that up?
So, yes, could I think this is more of a legal question. So I do want you to ask any factual questions to Mr. Calderon.
Oh, and then,
But
okay.
condition, as Mr. Calderon mentioned, the violation is Rule 201. And you are correct in citing temporary permits to operate once you submit an application. However, if you look at the chart of some of the hours of those unpermitted engines, they are quite close to 200. I can tell you without, eliminating the discretion of our permitting, it is very, very likely that an emergency internal combustion engine will have a permit condition that limits them to 200 hours. So it is very likely that if they operate, they would exceed that. They cannot come back to you for a variance. So we included that language in condition 2 to flatly not operate those engines because we do not want to put them into a scenario where they are exceeding what would be their permit condition and allowed to do it because they don't have a permit and they violated district rules.
I understand where you go. Let me ask the question for Mr. Calderon. So Mr. Calderon, are you familiar with District Rule 203C?
Correct.
What's your understanding of that rule?
203C?
Yeah. Is it, let me double check this.
There is no 203C.
Yeah, it should be 203A.
No, hang on, let me get that. Sometimes these things don't cooperate with me. Hold on.
If I could clarify, I think you're referring to Rule 202C.
202C, 202, not 203.
Thank you.
Yeah, 202C.
Okay, yes.
Okay, so what's your understanding of that section of the rule?
That it shouldn't be operated unless it has a permit, correct?
No, is that what it, can you read what it says?
Under the temporary permit?
Yeah.
Yeah.
What does it say? Can you please read that, the first paragraph only?
So existing equipment or existing agriculture permit unit, when an application for permit to operate is filed for existing equipment or an existing agricultural permit unit, the application shall serve as a temporary permit for operation of the equipment or agricultural permit unit.
So, so when they apply, like presume before February 28th as the condition require, the day they apply or when it's accepted by the agency, they will have a temporary permit to operate. Is that your understanding?
Yes,
Okay. So even though they may not get the final permit to operate, they'll have a temporary permit to operate.
yes,
So could they then apply for a variance for, let him answer if he can, and
As to whether they can apply for a variance, that is a legal question, so I'm gonna
So you're
answer that,
objecting?
but if you have
Are
a,
objecting, or you?
the question, in Rule 505 said you cannot, the board cannot grant a variance if they don't have a permit to operate. That's, I think, the health and safety code that Ms. Roberts cited. But a temporary permit to operate is a temporary permit to operate, So my question, if you know, is if they have a temporary permit to operate, once a consultant filed a permit application, could they then apply for, you can defer and say you don't know and leave it at that. Can they apply for a variance from those and for those engines that have a temporary permit to operate that they need relief from to operate and also not to exceed? The condition will apply the 200 hours.
respectfully, Mr. Balagopalan, there are no conditions on a temporary permit. They don't have any conditions, so they would not need variance relief.
Okay.
You have any further questions, sir?
Okay. No, let me see, there was, and I think, I problem with condition number 2, but I think, Ms. Roberts, you say you were going to look at rewording it, or if not,
So the district is not proposing to reword it, and it's because of the second paragraph in Rule 202C. You didn't have Mr. Calderon read it, but the intent is very clear that if you have a previous permit to operate, you may not operate it contrary to conditions. I can have Mr. Calderon testify, but it is a very standard condition for an emergency engine like this to have a maximum permitted hours per year. Even though the permit application has not been submitted, I can virtually guarantee you that when the permit to operate comes out, it will have a 200-hour cap on it.
I'm not disputing that at all.
But they will not have a cap if they are operating under a temporary permit, and they are very likely to exceed 200 hours. So the district opposes allowing essentially a loophole to allow them to operate under this rule as a temporary permit to operate.
Do you have any questions, further questions, sir? Because we're
So
ready to move on.
Can you bring up condition number 2, please?
So, Mr. Balakapon, just for clarity, for the sake of everyone's edification, where's the direction you're going?
I'm looking at, and I'm looking at the language, even and not even going to the thing about not operating, but the way it's worded is, okay, if you can read that, let me read that. Petitioner shall no later than February 2025 disconnect and render inoperative, including disconnecting from either of the engines referenced in condition number 1, which now we know only refer to the 2 permits above, or any on-site generator, but so one of the permitted ones, they have to have connected to the generator though. You cannot say any on-site generator now, because if you look at the table, the 2 engines are connected to the same generator. So if they had to disconnect any on-site generator, then the ones that are permitted and that we're getting relief from cannot be operated also. You see what I'm getting at?
No, as I read the condition, it's the internal combustion engines with those serial numbers, those are the unpermitted ones,
Right.
cannot be connected either to an engine or to any generator.
Okay.
So it's those unpermitted things that need to be disconnected and rendered inoperable. And yes, we do mean to include any generators, because that's what they normally power is the generator. So we want them disconnected from the generators.
Okay. I think you again made, are the engines connected to each other, Mr. Calderon? Or are they just connected to the generator?
To the generator.
To the generator. So if they're not connected, so you don't have to disconnect
No.
the engines,
We
correct?
would be willing to change it to just saying they have to be disconnected from any on-site generator, if that would make you happy. We
Yeah,
would-
but,
we would say that.
okay, the objective is not to make anybody happy. What we want to do is, are you finished?
No,
with-
I
Okay.
wanted to get the clarification.
Right, and she's clarified, so now we're going to go to closing arguments, Mr. Schaefer. Let's go.
Again, we reviewed these proposed interim variance conditions. I have no objections to these. We will comply with everything that is on this variance. And we'll do what we take to get in compliance with AQMD rules.
Thank you. Ms. Roberts, closing?
The district is unopposed to the granting of the variance subject to the 2 that we have discussed. I will highlight for the board the technical clarification. We ask for removal of one of the permit numbers in conditions number 1 and 6. The district has no opposition to changing condition 2 to limit it to just being disconnected from the generators. And I do want to highlight for the board, the district defers to the board on the due date for any hearing board excess emission fees. Thank you.
Thank you. Deliberation. Any member of the board desire to?
Okay, I do, sorry, can I?
Absolutely.
I do have a proposal for clarifying condition number 2. Whether, and I agree the intent that those unpermitted engines should not be operated or associated generator connected to the engine. So that's the intent. But the ones that we're giving relief for and that are permitted, they should be able to operate. And they should not disconnect the generator associated with that engine. So when I read it, any on-site generator, then it becomes problematic because the one that is permitted that is connected to that on-site generator has to be disconnected. I'm literally reading that, but I know that's not the intent. So my proposal is disconnect and render inoperative internal combustion engine with serial number, those are referenced there, 6487, unit 1B, 2B, 3A, and any associated generator with the engine. So so it's very clear you cannot operate those non-permitted engines and run the generator, basically. Now, as far as the last sentence, shall not operate these engines until a permit to operate. I'm going to respectfully disagree, having been in permitting. Once they have a temporary permit, they can actually operate it. They cannot exceed the 200 hours, even if they don't have a condition that is part of the rule. They cannot exceed the 200 hours without getting a variance or a violation. But nevertheless, once they submit a temporary permit, they have a temporary permit, they can actually run, that's a loophole actually. And I know it's the loophole, but that is a loophole in the rule and has been unfortunately considered like a loophole, So I think to say you cannot operate is misleading. It's not true. To contrary to my understanding how permits are, when a temporary permit to operate is, when they apply for, the companies do use this loophole all the time. They pay the higher fee and they have a temporary permit to operate. They'll operate it until the permit is issued. But the caveat is they have to comply with any applicable district rules and regulation. And in this case, they cannot exceed the 200 hours. So if they do, it's a violation. So that's the clarification I want to make. So when you say shall not operate, I would rather say shall not operate these engines, until a temporary permit to operate is issued. Until a temporary permit to operate pursuant to Rule 203C has been submitted and accepted by the district. Now, then it's up to them, and the inspector, if they run over the 200 hours, then they'll be in violation. But my understanding is they can, when they come back, when they're amending this in the regular variance, and if they want to include those engines, because they have now a temporary permit to operate, they can get relief also from based on the application number, while they may not have a permit number, from exceeding the 200 hours. That's my understanding. So it's misleading to say that until a permit to operate, because it could be 6 months from now or a year from now or whatever, when the permit to operate technically is issued, but they can operate under a temporary permit to operate. So that's the suggested language I have.
Any additional, Ms. Verdugo-Peralta?
I have other comments to make, but my initial question to Mr. Balagopalan, is that a practice or is that written somewhere as part of the rule? Because that's a big difference.
No, it is in the rule, 202C. When an application for a permit to operate is filed for an existing equipment, this is an existing equipment, okay, the application shall serve as a temporary permit for operation, which means a temporary permit to operate.
I understand that part. That's not really my question. My question is allowing or not allowing a company to utilize that loophole that you're talking about. That loophole that you're talking about, where is that written anywhere, or is it a practice?
No, this is the rule. This is 202C is that the language there. For a long time, so that has never been amended. I can elaborate a little further, but
I don't want to go down that rabbit hole.
Okay. So then it's not, so the rule gives the ability for a company that does not have let's say that they were operating a piece of equipment without a permit.
Okay, let me just stop you there. So what I'm just trying to abbreviate all of that and then ask to you, then number 2 needs to be reworded on the beginning as well as the end. Is that true?
Yeah, I think, the fact that you cannot, you have to disconnect any generator is misleading, because you need the generator to go with the permitted engine that you're giving relief from, okay? So it cannot be any generator, It's only the ones that are associated with the unpermitted equipment that they shouldn't operate until they have a temporary permit to operate. Now, once they have a temporary permit to operate, they have like one of those engines is, I don't know how many hours, they can go and not violate until they reach 200 hours.
Okay, I understand what you're saying.
Okay, all right.
However, does the district council agree with what Mr. Balagopalan is saying completely? Because if that's the case, then we do need to change number 2, or amend it, I should say.
The district does not oppose his first amendments as to just clarifying the disconnection is just to the generator for those unpermitted. Respectfully, at this time, the district doesn't agree that you can get a variance from a temporary permit to operate. We think that might actually conflict with the health and safety code. I have not seen such a variance granted because it's not clear what relief you're granting them from.
That's my concern.
I do believe the district's position otherwise is that this is essentially a loophole that through violating district rules, they would essentially be opted out of the otherwise requirement to not exceed 200 hours, and the district would not permit that. And respectfully, the district does not think it's misleading. This is a condition
Mhm.
of the variance. So we are saying you shall not that district rules wouldn't otherwise allow temporary permits, but in this circumstance, you shall not operate these engines.
Yeah, that's my concern.
Thank you.
Thank
Ms.
you.
Verdugo Parker, you
Okay.
good?
And so I'll leave that there. In reference to all of the exhibits that we have seen and the testimony that we have heard, I do believe that I can find for Amazon in reference to granting the variance. I think under the circumstances, and this is not going to be the one and only company, we're going to see many companies come before us in this situation due to that fire and due to the attempt of Edison to turn off power before it became a problem. So I'm in favor of granting the variance.
Any further deliberation from members of the board who've not spoken?
Oh,
Mr. Balakapalon, the floor is yours, sir.
no, I'm sorry.
No, so what I'm more interested in doing is getting to the motion. If you would like to make the amendments or whatever verbiage, let's make those in the motion as opposed to further deliberation. Are you okay with that?
Yes.
Okay, very well. So why don't you go ahead and proffer some language and then let's see if everybody accepts it.
Before we go that, the deliberation, but I do agree that, I can make the findings to grant the interim variance, can make the 6 findings, the one they are, for the 2 engines, they'll be imminently in violation. The 2, the circumstances lead was beyond the control. It's a PSPS events that led to it. They exercise diligence in filing. The interim variance will have an adverse impact on the petitioner. So the 6, I can make I'm sorry, those are not the 6 findings and excess emissions and so forth are part of the 6 findings. So I have no issue in granting the interim variance. The only issue I have is the way the language in condition number 2, and while we may disagree, they can act on the temporary permit. Once they apply, they have a temporary permit. Technically, they can go up to 200 before they violate a condition, even though they haven't got the permit. But let me prefer the proposed condition.
Perfect.
So, absolutely, yes. Okay. So petitioner shall no later than February 21st, 2025, disconnect and render inoperative internal combustion engines with serial numbers. I'm not going to, unit number 1B, unit number 2B, unit number 3A. Okay, but
Inoperative and render inoperative IC engine.
IC engines with serial numbers, I'm going to,
Or you said unit 1B?
unit 1B, the ones in unit 1 in parentheses, 1B, unit 2B, and unit 3A, and associated generator. And then, okay. Petitioner shall not operate these engines until an application for a temporary permit to operate.
An application for a temporary.
Permit to operate pursuant to is it 202C has been accepted by the South Coast AQMD. So that's the amendment
Okay, perfect. In the matter of Amazon.com Services LLC, case number 6267-1, facility item number 192999, I move that we grant an interim variance commencing February 20th, 2025 through
For 90 days.
Including the ex parte period.
April 21st.
until April 23rd, 2025 from the rules and subsections as listed in Exhibit A. With respect to the petitioner's permit, that's also encased in Exhibit A. The address is 3388 South Cactus Avenue, Bloomington, California, 92316. The conditions of the variance shall be set forth in Exhibit A. And the applicable fees will be paid to the clerk within 15 days from
January 31st of 2026.
January 31st of 2026. Is there a second to the motion? Second by Mr. Verdugo Peralta. Any further question or discussion on that
If I,
motion?
Yes,
if I may, Mr. Chair, I do believe that the parties agreed that the variance should only cover permit numbers G73658 and G73660.
Yeah, that was accepted
Thank you.
when you initially stated it about an hour ago. Mr. Balakapalan?
So did that, your motion include the proposed amendment I had? or-
Absolutely,
Okay,
absolutely.
okay.
Yeah, everyone is, to make sure we're on the record, the motion includes the Balakapalan recommendations that Ms. Verdugo Peralta seconded. We all accepted, the district is in agreement, Mr. Schaefer is in agreement, and off we go. So where are we in the vote? We were calling for Abraham? Aye. Verdugo Peralta?
Aye.
Balakapalan?
Aye.
Conager Macklin?
Aye.
Ali votes in the affirmative. The matter is hereby approved unanimously. Thank you very kindly, Mr. Schaefer. All right, we're going to move very expeditiously to Cal Portland Company, 322.
Take a few minutes, please.
How much time you?
5 minutes.
Okay,
so I
very
can
well.
Switch over and.
We'll take a 5-minute recess. We'll go off the record.
Thank you to everyone in this room.
Thank you. Ms. Roberts, this shouldn't be long, right?
Yeah.
All right.
We hope this is very easy.
Mr. Schaefer, how many people work for the company at that location?
At the location.
Yeah, you said,
So as far as Amazon Associates, there was 1,200.
okay, I thought that's what you said. I want to make sure I have the number correct.
Yes, and
A lot
then
of people.
probably around 200 other, managers.
Gotcha.
Is that not wrong?
We have several off 15. This one. This was a few miles off, I would, let's see if I.
Is your microphone on?
Sorry.
And we're off the record then.
Yeah, we're off. I was just curious, that's a huge facility.
Yeah, we don't, yeah, they're, let's just say, I don't have a problem getting my 10,000 steps in. You all have a wonderful day.
You too.
Which one is that? Yeah, I think I got it. Yeah, thank you.
All right.
What, you?
Yeah. Good. How was our marathon the other day? Yeah. So we need the. It should be, yes, they're not. Oh, okay.
Mr. Alberto, we're back on the record, sir. All right. Okay, so we have before us case number 3221-23 Cal Portland Crestmore Laboratories. And who do we have representing the petitioner?
Hi, my name is Deborah Murphy. I'm in-house counsel for Cal Portland Company. And I have with me Leanna East.
Hi, Leanna East, Environmental Manager.
Okay, and who do we have representing the respondent?
Good morning, Mr. Chair. Catherine Roberts on behalf of the Executive Officer.
All right, are there any witnesses that will need to take the oath today? Well, actually, we already did that, but do we have any, are you going to testify?
We actually both took the oath, but Miss East will be testifying primarily, yes.
Okay, and so we have a host of exhibits.
Yes, sir.
And so we're, Madam Clerk, we're marking the interim conditions from the district would be, okay, these are Exhibit A. And then there's a document from South Coast AQMD.
That would be a renewal permit?
Okay, the renewal permit. So these are your,
Yes, sir.
okay, these are your exhibits. So this would be Exhibit
1?
1. Okay, then the Crestmore Laboratory Emergency Generator Log is Exhibit 2. And then there's an email, there's communication from Jennifer Jones to Lena East.
It's a series of emails, and I will apologize up front to the board that it shows whoever prints it regardless of whoever
Yeah.
received
Yes,
it.
yes,
So
yes.
Microsoft glitch.
No problem, no problem at all. So that'll be Exhibit 3. And then Exhibit 4 would be the South Coast AQMD Executive Order 2501 dated January 7th, 2025, which happens to be my birthday. All right.
Oh, well, happy belated birthday.
Thank you, thank you. Okay, so we have the exhibits called. Ms. Murphy, the floor is yours for opening statements.
Thank you, Mr. Chair. Again, thank you, Mr. Chair and members of the hearing board. We appreciate this opportunity to present the request for the variance. My name is Deborah Murphy. I'm in-house counsel with Cal Portland Company. As we've already noted, Ms. East and I have already taken the oath this morning as well in relationship to the prior hearing. Petitioner Cal Portland Company is requesting an interim variance from the permit limitation of 200 operating hours for the emergency generator located at the Cal Portland Laboratory, which is at 1490 Rubidoux Boulevard in Yoruba Valley. We refer to this location internally as the Crestmore Lab, so anything you hear today will be referred to as the Crestmore Lab typically. It is, I believe we're talking about Rule 1110.2. And this is permit G66814 and facility ID 195306. As we are all very familiar with, we had recent red flag conditions through most of January, and power to the laboratory and offices was shut off by SoCal Edison many times, starting on January 7th of this year. And we have one emergency generator at the facility. It is subject to a permit, and this generator was utilized to power the laboratory. The laboratory is used to conduct testing on cement, concrete-related building materials, and other building materials that are associated with Cal Portland's operations within California and the Northwest in general. It is a central lab for the entire company. It is accredited by Caltrans and many other organizations to support critical infrastructure projects. Loss of power to the laboratory could delay supply of materials to Caltrans and to the public during times necessitating PSPS curtailments such as we saw last month. It could also result in a loss of accreditations for the laboratory itself, which would result in a significant disruption in the supply of materials necessary to the infrastructure of the Northwest in general. The generator has not been close to limits in prior years and only operates during actual power outages. We have not received any NOVs at the facility, and it is not operating under a variance other than the ex parte minute order that we've received, which was granted by this board on January 29th. The generator has actually not yet exceeded the hours. We did expect it would, but it has not yet exceeded. Ms. East reached out to AQMD during the power safety events in anticipation that it would be exceeded. As we know, a state of emergency was declared for LA County, and we are very grateful that we were not part of that, and the fires near us were not worse. But we are in Riverside County, a few miles from the LA County border, and so we did not have that. The fires by us were able to be contained very quickly, and we are extremely grateful for that. At present, the generator is at 189.42 hours, so we are very close. Given that the fire season has just begun and that we have the rest of the year to go through, we are asking for an interim variance and anticipating needing a regular variance for the remainder of the year, and that hearing has been scheduled already. We hope that neither we nor anyone else has to face this situation again, but we do have to prepare for it in the event and are here to ask for your authority in granting a variance.
Thank you, Ms. Roberts.
Thank you, Mr. Chair. The district is unopposed to a finding of good cause, and if the board proceeds to the merits, subject to the inclusion of the conditions that are now Exhibit A, the district is unopposed to the granting of the variance.
Thank you very kindly. Would you like to call your first witness, Ms. Murphy?
Yes, Mr. Chair. I would like to call Miss Leanna East. Leanna, would you please state your name and spell your name?
Yes, hi, Leanna East, Leannaeast.
And Miss East, you took the oath of being a witness earlier today?
I did, yes.
Thank you. Who is your current employer and what is your job title?
My current employer is Cal Portland Company, and my current job title is Environmental Manager.
And what is your degree in?
Environmental Geology.
Are you familiar with the Crestmore Laboratory?
Yes, I am. I worked there prior to my current role.
And what was that role?
My prior role was research chemist.
Okay. As part of your current duties, you're responsible for environmental compliance at the Crestmore Laboratory?
Correct. I'm responsible for the environmental compliance there, which does include reporting for the generator.
Okay. And what air emission sources do we have at the lab?
Just the emergency generator.
Okay. What type of a generator is that?
The generator is manufactured by Caterpillar and is a 762 brake horsepower Tier 4 internal combustion engine.
Okay.
Combustible, sorry, engine.
And we have a permit for that generator?
Yes, we have a current permit and we're in the process of renewing it since the annual is due next month.
And the fee for that was just paid?
Correct, on Monday.
Okay, great. Thank you. So we have Exhibit 1. If you would look at that, that is our current permit. Is that correct?
Correct.
Okay. And it shows a next renewal date of March 16th?
That is correct.
Okay. So, and the fee has been paid for that, so we should have a renewal of the permit before the proposed variance expires, correct?
Correct.
Okay, thank you. Has the facility received any NOVs?
No.
Okay, and I think the board is very familiar with the 200-hour permit limitation for emergency generators, but that applies to this generator as well?
Yes, that's correct. Per condition 4 in our permit, we're limited to the 200 hours per calendar year, which includes no more than 50 hours for maintenance and testing purposes and 4.2 hours per calendar month for maintenance and testing purposes.
Okay, so how many hours is the generator operated so far?
For 2025, the generator has operated approximately 189 hours.
And that's all been in January?
Correct.
Okay, and during timeframes of PSPS?
Yes, from January 3rd or January 7th to January 23rd.
Okay. And I believe you have a log of the generator hours as Exhibit 2?
That's correct.
Okay. And that's been prepared by you?
Yes.
Thank you. So how many hours has the generator typically operated?
In previous years?
Yes.
In 2023, the generator operated approximately 35 hours, and in 2024, the generator operated approximately 67 hours.
Okay, so this is purely due to the horrific conditions we faced in January of this year.
That's correct.
Okay. So let's see. Do you have any notices from South Coast Edison of power shutoffs?
Yes, we have several emails notifying us of the possibility of power shutoffs, as well as emails confirming that actual shutoffs are occurring.
And those are at Exhibit 3?
Correct.
Okay, so the first one of those was on January 7th.
Yes.
And when did we lose power?
We lost power that night on January 7th at 7:29 p.m.
Okay. So what goes on, and I should have asked you this earlier, I apologize. What goes on at the laboratory? What is it used for?
Sure. The Crestmore Laboratory is an accredited lab that provides QA/QC services to ensure that the company is delivering consistent quality products to our customers, which does include key infrastructure projects for Caltrans. In addition, the lab is the main hub for the company's research and development, where we're actively researching ways to reduce our carbon emissions to meet the state's carbon neutrality goals.
Thank you. So we ultimately regained power on the 23rd, it looks like, of January 23rd. Is that correct?
That's correct.
We had a series of start and stops with SCE.
Yes, that's correct.
Okay. So you reached out to the district about a variance. Is that correct?
Yes, on January 14th, I reached out to the district. At that time, we were around 116 hours. So we had the concern that we were going to approach it quickly since we were only 2 weeks into the calendar year. And I was recommended by Terrence Mann to submit an application for a variance, which we did.
And when was that application filed?
That was filed on January 23rd.
Right, and I believe the board has a copy of the petition for the variance. And we were granted an ex parte variance on January 29th, correct?
That is correct.
Okay. And the generator has not been used at any time this year except during power shutoff due to PSPS?
That is correct. On January 20th, there was one maintenance event. The generator was turned on for 2 minutes just to make sure that it was operating and the fuel levels were still fine since we had been running it so often. But other than that, the generator has only been on due to the PSPS events.
Thank you, Ms. East. At this time, I would move that there be a finding of good cause for the grant of an interim variance.
All right, thank you, Mr. Roberts. The witness is yours on cross.
No further questions for this witness. Thank you.
Very kindly, members of the board. Do you have any questions of the witness?
Just
Mr.
Just a
Colin.
clarification, Ms. East. So you're aware that the district rule 118.1 doesn't apply because you're a non-critical facility, so you cannot subtract those hours from the 200 hours, correct?
Yes, that's correct.
Okay.
Yeah.
And I think in your turn, you mentioned the emergency declaration didn't apply to your area.
Correct.
Yeah, that's correct.
And I'll save the next question for the next phase on how you calculate emissions. So,
Okay,
okay, I have no further questions.
thank you.
Ms. Verdugo Peralta.
I was just curious because I'm reading the emails that went back and forth from Edison to your company. Did you ever have any actual phone calls with any of the parties from Edison, or was it strictly just email?
From my understanding, it was just email.
Because on these emails, it says that's not the place to respond. So I was just curious whether there was any back and forth between the parties.
Unfortunately, I can't answer that question. Much of the communications would have been with our energy manager associated with it. And as we all know, Edison was slightly busy. So
Slightly.
I'm sure that even if there were calls back and forth, they were probably a little convoluted.
Okay, thank you.
Thank you. Thank you, Ms. Murphy, on closing.
Thank you, Mr. Chair. As we've noted, the Crestmore Laboratory is critical to the company's operations and to the infrastructure of the area generally. The operation for the emergency generator is close, but not quite exceeding the 200 hours. It was, we reached out to the district as soon as possible, understanding that we were still under power shutoff emergencies and that we might be exceeding imminently, and filed the petition in advance, fortunately, of exceeding the limit, as we have not yet quite exceeded the limit. Operation is due solely to PSPS events, and we request that there be, we believe we would be in violation of Rule 1110.2, but that we would clearly be in violation of a permit condition if we go over the 200 hours. And we request that you find good cause for granting an interim variance. We oppose no conditions imposed by the district.
Ms. Roberts?
Thank you, Mr. Chair. The district does not oppose a finding of good cause and proceeding to the merits. Based on Ms. East's testimony, I think it's clear that this facility is imminently to be in violation of their permit condition and Rule 203 as a result of that. We agree that based on that testimony that these are the result of public safety power shutoff and couldn't have been avoided. We do agree that based on her testimony that there has been reasonable diligence in the petitioning based on when they started accruing significant hours and it became likely that a variance was needed, they did act expeditiously to file. And we do agree that with their testimony that there would be an adverse impact to the petitioner. So we do not oppose making the findings for good cause.
All right, on deliberation, Mr. Palaka-Palan.
Yeah, I do agree. I can make the good cause finding that they're going to be imminently in violation and circumstances due to the PS events could not be avoided. And also, I really applaud the Ms. East be diligent contacting the district and getting the information and filing for the ex parte. So they were actually quite diligent. We don't always see that from some of the companies in being diligent. So, and the impact will be, you cannot run the lab if we don't grant that. So so all those, I can make the full finding and grant, agree for that the good cause finding can be made.
Any additional deliberation? Hearing in the matter of Cal Portland Company, case number 3221-23, I move that we find good cause to proceed to a hearing for an interim variance and absence of notice to the public based on our discussion ability to make the findings for good cause. Is there a second?
Second.
Second by Ms. Verdugo-Prouch. Any further question or discussion? Hearing none. Abraham? Aye. Verdugo-Prouch.
Aye.
Palaka-Palan?
Aye.
Carnahan-Macklin?
Aye.
Ali in the affirmative. We have approved this unanimously. We'll move to the second phase. And so we'll go ahead and turn the floor back over to you, Counselor. And then you can provide an opening, and we will ensure that all testimony and documents from the good cause finding will be included in the next phase with respect to determining if in fact the members of the hearing board will grant the interim variance. Floor is yours.
Thank you, Mr. Chairman. But on that note, I think I've given as much of an opening as you all probably want to hear. We have considered opportunities to limit usage. There are offices associated with the Crestmore lab, but the power for the generator is going just to the laboratory. We have our engineering staff on board there as well as just the laboratory staff, but we have limited operations and do agree to limit operations except in the event of an absolute emergency that would necessitate worker safety or sprinklers running or something of that nature. May I call a witness or Ms.
If you're so inclined, you can call the witness if in fact you're inclined, if there's some questions you might have of her.
Really, just one. Thank you. Ms. East, do you have any objection to calculating excess emissions and reporting to the district as they may direct?
No, we calculated the emissions as part of our application, and we're willing to estimate those moving forward.
Thank you.
Thank you, Ms. Roberts on cross.
I just have one question for you, Ms. East. Sure. Ms. East, did you have a chance to review the interim variance conditions that were submitted by the district?
Yes.
Do you have any opposition to complying with the proposed conditions?
No, I do not. The only question that we had was for the condition 2. Oh, it was modified? Okay, then no.
Okay, thank you. No further questions.
Thank you. On deliberation, members of the board. Actually, I'm sorry. Did we have any questions of the witness? No further questions?
I think to me for. Yes, Mr. East, I just, you reported, you calculated 92.73 pounds per day now.
Yes.
And what was the emission factor you used for calculating the pounds?
Let me pull that up. I know our emissions calculations were made based on our manufacturer's specification sheet. Uh, I'm sorry, can you repeat the question?
When I look at the permit, the emission factor includes the non-emission hydrocarbon and NOx, which is 4.8 grams per every cost per hour. So NOx will be lower than that. So I'm just wondering what number you used for the NOx, or you use something else.
Oh, I see. I have the spreadsheet on my laptop. I don't remember the specific numbers, but they were very close to what is permitted. We based our calculations off of the spec sheet.
Is that something you run by the AQMD to verify it's correct or not? Or is that something you're willing to do just to?
We will do that.
Yes, we're willing to do that.
Okay,
Thank you.
Thank you. Any additional questions? Okay, so we've just want to make sure we're good. We're going on both sides.
The district would propose retaining the same date that the clerk proposed for the last variance, which would be January 31st, 2026, to be inserted in condition 3.
Okay. Just want to make sure there's no further deliberation. All right. In the matter of Cal Portland Company, case number 3221-23, I move that we grant an interim variance commencing January 1st, 2025. Madam Clerk, and continuing through. I'm sorry. Wait, hold on 1 second. So then we need to, okay, gotcha. And so we're going to continue that. So that'll be February 20th, 2025 through March.
For 90 days.
Okay, 90 days, including the ex parte, okay. Ending on April 23rd, 2025. From the various rules and subsections as detailed in Exhibit A. For the petitioners, permits as well as operating numbers also encased in Exhibit A. The address is 1490 Rubidoux Boulevard, Hoopa Valley, California, 92509. The conditions of the variance shall be set forth in Exhibit A, and the district will in fact collect the fees in January of 2026. All right, is there a second to the motion? Second by Dr. Abraham. Any further question or discussion on that? Hearing none. Dr. Abraham, how you cast your vote? Ms. Verdugo Peralta?
Aye.
Mr. Balakapalan?
Aye.
Ms. Conager Macklin.
Aye.
And Ali votes in the affirmative. The second, moved by Ali, second by Dr. Abraham. The vote has been unanimous with Ali voting affirmative. The case is now closed. You folks can have a phenomenal morning. We're off the record and adjourned at 11:27 a.m.
Thank you.